After a break, the next panel focused on civil rights and Judge Roberts' record in private practice and while serving the Reagan administration. This is an hour.
Our next witness is Congressman John Lewis of Georgia, an architect of the historic March on Washington in August of 1963, been the representative for Georgia's 5th Congressional District since November of 1986 when he was elected, took office in January, BA in Religion and Philosophy from Fisk University, graduate of American Baptist Theological Seminary. Thank you for crossing the rotunda today, Congressman Lewis, and we look forward to your testimony.
Thank you very much, Mr. Chairman. Mr. Chairman and distinguished members of the committee, I'm honored to be here today. As many of you know, this is not the first time I've come before this committee. I was here 14 years ago when the nomination of another justice to the Supreme Court moved me to speak out. I'm here today with the hope that this committee will hear my words and take heed. When I was growing up in rural Alabama, I saw those signs that said white men, colored men, white women, colored women. I used to ask my parents, my grandparents, why racism? Why racial discrimination? And they would tell me, don't get in trouble. Don't get in the way. As a participant in the civil rights movement of the 1960s, I decided to get in the way. I was beaten, arrested, and jailed more than 40 times for peaceful, nonviolent protests against legalized segregation in the South. During that time, I saw American citizens with their head cracked open by nightsticks, lying in the streets, weeping from tear gas, trampled by horses, and attacked by police dogs, calling helplessly for medical aid. Back then, legalized discrimination was enforced by state and local officials. The federal government was our only hope, and we depended on the Supreme Court to act as a sympathetic referee in the struggle for justice and civil rights. I remember on one occasion when the court issued a decision on public transportation, an elderly black woman was overheard to say, "God Almighty has spoken from Washington." In 1965, Judge Roberts was only 10 years old. He may be a brilliant lawyer, but I wonder whether he can really understand the depth of what it took to get the Voting Rights Act passed. The right to vote is precious, almost sacred. It is the most powerful, non-violent tool we have in a democratic society. As many of you know, I gave a little blood on the Edmund Pettus Bridge, but some of my friends and colleagues gave all they had, their very lives, for the right to vote. People stood day after day in unmovable lines to pass their so-called literacy tests. They had to interpret certain sections of the Constitution, count the number of jelly beans in a jar, or the number of bubbles in a bar of soap to register to vote. I fear that if Judge Roberts is confirmed to be the Chief Justice of the United States, the Supreme Court will no longer hear the people's cries for justice. I feel that the leadership of the court will promote politics over the protection of individual rights and liberties. If the federal courts had abandoned us in the civil rights movement in the name of judicial restraint, we might still be struggling with the burden of legal segregation in America today. Judge Roberts' memos reveal him to be hostile towards civil rights, affirmative action, and the Voting Rights Act. He has even said that Voting Rights Act violation, and I quote, should not be made too easy to prove. Under the court's decision in Mobile versus Bolden, the court weakened the Voting Rights Act. Under this ruling, many political subdivisions would have been permitted to maintain at-large election system, diluting minority voting strength. This may be less obvious than the violence and intimidation of the 1965, but it is no less harmful to our nation's principles of inclusive democracy. Section 2 has been successful in reducing barriers and has increased the number of minority elected officials. There is no doubt, Mr. Chairman, in my mind, that had Judge Roberts' narrow reading of the Voting Rights Act prevailed, few people of color will be serving in Congress and at both the state and local level today. As our nation is still reeling from the tragic Hurricane Katrina, the timing of these hearings could not be more significant. What happened in New Orleans and along the Gulf Coast of Alabama, Mississippi, and Louisiana exposed the issue of race, class, and fairness yet again. We are still a nation deeply divided by race and class. All Americans, by every race, or every religion, or nationality, whether they are women or men, gay or straight, or people with disability, all of us need equal access to a fair and independent judiciary to ensure equal justice under the law. The stakes are higher than ever. We cannot afford to elevate an individual to such a powerful lifetime position whose record demonstrates such a strong desire to reverse the hard-won civil rights gain that so many of us sacrifice so much to achieve. We have come a great distance. We cannot afford to stand still. We cannot afford to go back. We must go forward to the creation of one America. My friends, members of the Senate, I implore you to get in the way. Thank you, Mr. Chairman.
Thank you very much, Congressman Lewis, for those very passionate remarks. Our next witness is Commissioner Jennifer Braceras, U.S. Commission for Civil Rights, taught at the Civil Law School, is a visiting fellow at the Independent Women's Forum. In the year 2000, Massachusetts Lawyers Weekly rated her as one of the state's top 10 lawyers of the year. Practiced law with the Boston firm of Ropes and Gray. Thank you for joining us, Commissioner Braceras, and we look forward to your testimony.
Thank you. Chairman Specter, Senator Leahy, members of the committee. My name is Jennifer Braceras. I am a resident of Massachusetts and a member of the Massachusetts Bar and the Hispanic National Bar Association. I am, as you said, a visiting fellow with the Independent Women's Forum, and I am privileged to serve by appointment of the President as a Commissioner on the United States Commission on Civil Rights. I am honored to be here today to support the nomination of Judge John Roberts to be Chief Justice of the United States. Although I do not know Judge Roberts personally, I am generally familiar with his background and record. His distinguished career and his testimony before this committee make clear to even the most casual observer that Judge Roberts is eminently well qualified for the post. Despite these obvious qualifications, however, opponents of Judge Roberts criticize his record on a variety of matters that loosely fall under the umbrella of civil rights. These critics allege that Judge Roberts' confirmation to be Chief Justice will somehow be harmful to women and minorities. These charges are at best misplaced and at worst deliberately misleading attacks that would have been leveled against anyone nominated by this president. There are at least 5 reasons why such criticisms are without merit. First, many of the specific criticisms of Judge Roberts' record involve positions he advocated as a lawyer in the administrations of Presidents Ronald Reagan and George H.W. Bush. Some of the subjects that have elicited criticism by interest groups include school busing, racial quotas, the revision of the voting rights legislation to seek equal electoral results as opposed to equal access, and the theory of comparable worth. Published reports indicate that the positions taken by Judge Roberts in this capacity, as a lawyer for the Reagan and Bush administrations, are broadly consistent with the views of the American people and fully within the political mainstream. But even if they were not, the arguments expressed by Judge Roberts as a young man decades ago are arguments on behalf of the administrations for which he worked, not the views of a neutral umpire asked to rule on particular legislation. Judge Roberts' view of the judicial function does not contemplate the imposition of his own policy preferences from the bench. His commitment to judicial restraint should give Americans of all political viewpoints great comfort. Second, it is clear from the public record that Judge Roberts supports the vigorous enforcement of our nation's anti-discrimination laws. In his executive branch memos, Judge Roberts repeatedly defended the, quote, bedrock principle of treating people on the basis of merit without regard to race or sex, unquote. And he argued numerous times for the executive branch to prosecute claims of unequal treatment to the fullest extent of the law. Third, as an advocate, Judge Roberts has been on both sides of controversial civil rights questions. This broad experience should give the American people faith in Judge Roberts' ability to understand the complexity of controversial issues. Fourth, it is clear that Judge Roberts has a strong commitment to equal opportunity and to the anti-discrimination principle embodied in the 14th Amendment and codified in the Civil Rights Act of 1964. He has written, and I quote, "Before the law, we do not stand as black or white, Gentile or Jew, Hispanic or Anglo, but only as Americans entitled to equal justice." Certainly, there is nothing extreme or unusual about this view. To the contrary, it embodies the American ideal. It reflects the aspirations of the 14th Amendment, which were given life by the court in Brown v. Board of Education and by the framers of the 1964 Act. Finally, and perhaps most importantly, irresponsible rhetoric that a court led by Judge Roberts would be hostile to civil rights misinterprets the role of the court in our democracy. This rhetoric is based on several deeply flawed premises. First, such rhetoric presumes that it is the job of the court to create new rights in response to evolving circumstances. It is not. Our Constitution guarantees certain basic rights which the courts must, of course, enforce. Legislatures, both state and federal, may expand upon those rights or create new ones, provided that they act within the scope of their constitutional authority. If citizens are in any way dissatisfied with the scope or reach of current law, it is to their democratically elected representatives, not the courts, that they must turn. Second, Judge Roberts' critics erroneously presume that courts should interpret all statutory language expansively. That is also not their role. Their role is to apply statutes as written.
Commissioner Braceras, could you summarize the balance of your statement, please?
Sure.
Your full statement will be made a part of the record, as will all statements.
The Supreme Court is neither the first nor the last word on civil rights, or any other issue for that matter. Each of the three branches of government has a role to play, and Judge Roberts respects and understands these distinct roles. In conclusion, I submit that Judge Roberts' critics have it wrong. Judge Roberts' commitments to the vigorous enforcement of our nation's civil rights laws and to the bedrock principles of judicial restraint, judicial review, and equal opportunity will make him a justice of whom all Americans can be proud. And I urge you to confirm him as the next Chief Justice of the United States.
Thank you very much, Commissioner Braceras. Senator Leahy has asked for recognition before we complete the panel. Senator Leahy.
Thank you, Mr. Chairman. A classmate of mine from law school was supposed to testify. We changed this by a week, is unable. I just want to make sure the testimony of John W. Dean is put in the record at the appropriate place.
Without objection, it will be made a part of the record. Our next witness is Mr. Wade Henderson, who's the director of the Leadership Conference, a longstanding leader on civil rights. Before his current position, he was Washington Bureau Director of the NAACP, serves as the Rao Professor of Public Interest Law at the Clark School of Law, a graduate of Howard University, and the Rutgers University School of Law. I know you had talked to David Rogg about a postponement of the hearing, and then events overtook us, and the postponement did take place. Thank you for joining us today, Mr. Henderson, and the floor is yours.
Well, good afternoon, Mr. Chairman and members of the committee, and thank you, Mr. Chairman, for your courtesies in giving us an additional week because of the aftermath of Hurricane Katrina. Again, my name is Wade Henderson, and I'm the Executive Director of the Leadership Conference on Civil Rights. The Leadership Conference is the nation's premier civil and human rights coalition and has coordinated the national legislative campaigns on behalf of every major civil rights law since 1957. The Leadership Conference's 190 member organizations represent persons of color, women, children, organized labor, individuals with disabilities, older Americans, major religious groups, gays and lesbians, and civil liberties and human rights groups. It's a privilege to represent the civil rights community in addressing the committee today. Based on reasons I will highlight here today, discussed at greater length in my written testimony, and after a careful review of John Roberts' available record, including his testimony before this committee, the Leadership Conference is compelled to oppose his confirmation to the position of Chief Justice of the United States. In the last several days of testimony, Judge Roberts has failed to distance himself from the anti-civil rights positions he has advocated. We have heard nothing demonstrating his commitment to ensuring that the federal government will continue to play a strong role in protecting civil and human rights of all Americans. To the contrary, all evidence indicates that Judge Roberts would use his undeniably impressive legal skills to bring us back to a country that most of us wouldn't recognize, where states' rights trump civil rights, where the federal courts or Congress can see discrimination but are powerless to remedy it. This is not the America in which most Americans want to live. As we've seen over the past 2 weeks in the wake of Hurricane Katrina, when the federal government's role is diminished, the least among us suffer most. Our nation fought a civil war over the meaning of equality in our Constitution and the role of the federal government in ensuring that equality, and then engaged in a great debate about the power of the federal government to enforce the 13th, 14th, and 15th Amendments. Reconstruction failed, and African Americans were returned to a position of near servitude because those who advocated for weak federal power won. It wasn't until decades later, when the court outlawed state-sponsored segregation in Brown versus the Board of Education, followed by the enactment of a series of civil rights statutes by Congress in the 1960s that are now the bedrock of our national commitment to equality of opportunity, that the federal government stepped in as a champion of equal justice under law. However, in recent years, we've seen the rise of a political movement that is an eerie parallel to the post-Reconstruction period. Today, there are those who, in the name of judicial restraint, advocate for a federal retreat in the area of civil rights. While our Constitution speaks of fundamental rights, some oppose the federal courts or Congress using the Constitution to protect individuals against violations of those rights. John Roberts has written that federal courts should not be empowered to invalidate, quote, widely accepted state practices, unquote, even if such practices prevent African Americans and others from having equal opportunity in voting. If his view had prevailed, our country's voting rights revolution would never have happened. Would Judge Roberts have approved of poll taxes or literacy tests because those were, quote, widely accepted practices? Despite the strong recommendation from a very conservative member of the Reagan administration's civil rights team, John Roberts advised against intervention in a sex discrimination case against the Kentucky prison system, contending that discriminatory treatment of men and women in the prison's vocational program was, quote, reasonable in light of tight prison budgets, unquote. Would Judge Roberts then apply the same argument to equal educational opportunities for women generally? Could states, in the name of saving money, refuse to provide equal health services to men and women? In John Roberts' view, Congress could exclude all school desegregation cases from the jurisdiction of the federal courts. This is, in effect, a pre-Brown vision that fits squarely into the objective of preventing the federal courts from fulfilling the promise of the 14th Amendment. As many commentators have made clear, John Roberts is a gifted and intelligent lawyer and advocate, but that is not the test for determining whether he is fit to lead the highest court in the land. Rather, the test is whether John Roberts has demonstrated he is committed to the fundamental principles on which our country was founded, and whether his vision of America matches the expectations of mainstream Americans. John Roberts has failed this test. Therefore, the Leadership Conference on Civil Rights has no choice but to oppose his confirmation. America can and should do better. Thank you very much, Mr. Chairman.
Thank you very much, Mr. Henderson. Our next witness is Commissioner Peter Kirsanow of the U.S. Commission on Civil Rights, had been Labor Counsel for the City of Cleveland. He's the chair of the Board of Directors of the Center for New Black Leadership, on the advisory board of the National Center for Public Policy Research, a graduate of Cornell, a law degree from Cleveland State with honors. Thank you for coming in today, Commissioner, and we look forward to your testimony.
Thank you, Mr. Chairman, Senator Leahy, members of the committee. I am Peter Kirsanow, a member of the U.S. Commission on Civil Rights and a partner in the Cleveland, Ohio law firm of Benesch, Friedlander, Copeland, and Aronoff in the labor and employment practice. I'm here in my personal capacity. The U.S. Commission on Civil Rights was established in 1957 to, among other things, act as a national clearinghouse for information related to denials of equal protection and discrimination. And in furtherance of that function, my assistant and I reviewed the opinions of Judge Roberts while in the D.C. Circuit related to civil rights, and also a Supreme Court advocacy related to civil rights, particularly with respect to prevailing civil rights norms, jurisprudential norms, with particular attention to the 1964 Civil Rights Act and the 14th Amendment. Our examination reveals that Judge Roberts' approach to civil rights is consistent with mainstream textual interpretation of the relevant constitutional and statutory authority and governing precedent. His opinions evince appreciable degrees of judicial restraint, modesty, and discipline, and in short, Judge Roberts' approach to civil rights is exemplary. It is legally sound, intellectually honest, and with a deep appreciation for the historical bases for civil rights laws. And our examination also reveals that several aspects of Judge Roberts' civil rights record have been mischaracterized, and sometimes the criticisms have been sorely misplaced. For example, conflating his counsel and advocacy on the part of clients with his own personal policy preferences. Just three brief examples. First, some have contended that during the 1982 reauthorization of the Voting Rights Act, Judge Roberts had adopted an anti-civil rights approach to or interpretation of the act. But the record definitively shows that Judge Roberts had consistently counseled in favor of reauthorization of the entire act as is, and he expressed the administration's concern that a substantive redefinition of Section 2 could risk introducing confusion and uncertainty into what had already been considered one of the nation's most successful pieces of civil rights legislation. Judge Roberts continued to advocate on behalf of his client for vigorous enforcement of Section 2 even after adoption of the effects test. Second, some have claimed that Judge Roberts' position on affirmative action is regressive. Most of these criticisms relate to his questioning of a 1981 U.S. Commission on Civil Rights report pertaining to affirmative action. A detailed examination of that report shows that not only was Judge Roberts' criticism correct, but imperative. The Commission's report was inconsistent with the status of the law in 1981 when issued and fails to comport with the post-Adirondack Constructors versus Pena, Grutter versus Bollinger affirmative action norms of today. Judge Roberts had properly advised against unlawful racial quotas and set-asides untethered to a proof of discrimination. He supported the, and we heard it earlier, quote, bedrock principle of treating people on the basis of merit without regard to race or sex, end quote. A third contention, unsupported by examination, is that Judge Roberts' arguments before the Supreme Court in civil rights matters were somehow extreme rather than mainstream. Probabilities would dictate that if Judge Roberts had somehow slipped past the Supreme Court's gatekeepers and got to make extremist arguments before the court, that the court would have dismissed virtually 100% of those arguments, or at a bare minimum, far more than 50%, which is the fate of most arguments before the court. Again, a review of the record shows that Judge Roberts' arguments with respect to civil rights were agreed to by the Supreme Court 71% of the time, hardly indicative of positions outside of prevailing civil rights norms. And these justices who agreed with him included those who might colloquially be described as conservative, such as Justice Rehnquist, who agreed with him 75% of the time, or Justices Scalia and Thomas, each of whom agreed with him 71% of the time. But they also include justices colloquially described as liberals, such as Justice Ginsburg, who agreed with him 60% of the time, Justice Souter 59% of the time, Justice Stevens 59% of the time, and even Justice Thurgood Marshall, the premier civil rights litigator, probably forever, agreed with his advocacy position 67% of the time, almost as much as Justices Scalia and Thomas, and more than Justice O'Connor. Mr. Chairman, it's respectfully submitted that Judge Roberts' 25-year record with respect to matters pertaining to civil rights demonstrates an unwavering commitment to equal protection and a comprehensive understanding of our civil rights laws that would make him an outstanding addition to the Supreme Court, particularly in the capacity of Chief Justice. Thank you, Mr. Chairman.
Thank you very much, Commissioner. Our next witness and final witness on this panel is Judge Nathaniel Jones. Had served as Executive Director of the Fair Employment Practice Commission, was an Assistant U.S. Attorney for the Northern District of Ohio, directed NAACP litigation as General Counsel for 10 years, a graduate of Youngstown State University, both bachelor's and law degrees, and served on the Court of Appeals for the Sixth Circuit, and is now retired. Judge Jones, thank you for coming in today, and we look forward to your testimony.
Thank you, Mr. Chairman and Senator Lay and esteemed members of the committee. I am honored to have this opportunity to appear as a witness today to, I hope, assist you to more effectively evaluate the fitness of John G. Roberts to be confirmed as Chief Justice of the United States by providing an historical perspective. Mr. Chairman, I ask that my full statement be introduced in the record.
Without objection, Judge Jones, it will be a part of the record.
Thank you. My acceptance of your invitation to offer testimony is prompted by my conscience and is driven by a profound obligation to introduce into the record an historical perspective, and in doing so I join with my colleague John Lewis, whose life is a personification of courage. And I wish to add to his description of the struggle for civil remedies and civil rights remedies. You are confronted here, I suggest, with a serious constitutional and moral responsibility. You are considering, under the Constitution's advice and consent clause, the fitness of a Supreme Court nominee who has, in the past, argued against the use of federal power to eradicate the vestiges of slavery and the badges of servitude. This record triggers serious questions and a vigorous inquiry into the whys. So much of the nominee's advocacy as a government lawyer and counselor was in the direction of against the implementation of civil rights remedies. There's been a lack of balance. While I appear in my own right, more importantly, I am invoking the voices of distinguished legal giants whose voices have been stilled by time. Dean Charles Hamilton Houston, Justice Thurgood Marshall, Judge William H. Hastie, Clarence Mitchell, James A. Nabritt, Judge Spotswood Robinson, Judge A. Leon Higginbotham, and many others who have my, and I trust your, deep and enduring respect. These individuals believed in the Constitution, and they hoped that government would step up and protect the rights of the minorities and the persons who were victims of majoritarian excesses. They fashioned a strategy for using the law and the courts to attack racial segregation. They set the stage for the development of remedies to remove the stain of racial segregation that law and the courts imposed upon this land. You may ask why I invoke their names and speak in the voice of these towering legal giants and hold up the contributions they made to the advancement of civil rights jurisprudence. My reason is twofold. First, my professional and personal experiences qualify me to do so. Second, since he was nominated by the President, serious questions have been raised concerning Judge Roberts' views about the relevance and legality of remedies aimed at ending racial discrimination. Unfortunately, few Americans know or have focused on or are familiar with the history of the myriad ways the positive law and legislatures and courts reinforced and perpetuated racial discrimination in America. It is up to this committee, therefore, to assure that at the very least, the next Chief Justice of the United States understands that history, and most importantly, why remedial action was and continues to be necessary. Those courageous souls who laid the foundation for overturning decades of legally enforced racial segregation are calling out to you, and I echo their voices, to respect their labors and heed their lessons. One's fitness to be the Chief Justice transcends stellar economic and academic achievements and acknowledged professional competence. The nominee's views and his documented activist attempts to thwart the federal court's efforts to dismantle segregation schemes, the courts themselves permitted to be erected and sustained, bring into play something much more fundamental than technical skills. The critical question before you is one of values, not competence. To understand why this is true, one need only consider the most wretched decision the Supreme Court ever handed down in a case of human rights, Dred Scott versus Sanford. The author of that decision, Chief Justice Roger Taney, was undoubtedly highly qualified from a technical and professional standpoint. Yet faced with the fundamental question of whether a former slave had standing to sue to retain his newly acquired free status, Justice Taney wrote that black people were not persons within the meaning of the framers of the Constitution. Similarly, Henry Billings Brown, the author of the 1896 Plessy versus Ferguson decision, had impressive professional credentials and academic as well. He was a graduate of both Harvard and Yale, and his prior judicial experience, which was on the Sixth Circuit Court of Appeals, but he lacked the values that sensitized him to understand why the 13th, 14th, 15th Amendments had to become a part of the Constitution. On the other hand, it was Justice John Marshall Harlan, the lone dissenter, a graduate of a much smaller law school, the son of slave owners, who gave us the final word. And his word is his word that has rung through the years. Gentlemen and lady, I would conclude with this observation. Abraham Lincoln stated in his famous speech in 1862 to the Congress that, fellow citizens, we cannot escape history. And it was George Santayana who said, those who cannot remember the past are condemned to repeat it. But given the nature of the exchanges that I have observed taking place this week in connection with the hearings, I would leave with you the words of Dr. Martin Luther King. He asked and answered these questions. Cowardice asked the question, is it safe? Expediency asks the question, is it politic? Vanity asks the question, is it popular? But conscience must ask the question, is it right? I leave you with those challenges.
Thank you very much, Judge Jones. Our practice in the committee is to have 5-minute rounds. In setting the witness list, we had many requests. And we have honored as many as we could with some 30 witnesses equally divided between Democrats and Republicans. Usually there's a tilt for the majority, but my decision was to divide them equally. We have a very long road ahead of us. This is the second panel on 6th, and it is my hope that the questions will be abbreviated. We wanted to see you and hear you and have your statements and have your views and look you in the eye. I personally will have just a few questions which I will want to ask. And let me start, Congressman Lewis, with you, with great appreciation for what you have done. The Voting Rights Act, which we labored through in 1982, and I was there in Senator Dole's office, and Senator Kennedy was deeply involved, and so was Senator Leahy, and so many of us were, to get the effects test instead of the intent test so that we have some realistic enforcement of civil rights. Senator Kennedy and I have already conferred. He came to me, said, let's renew the bill this year, the act this year if we can. It's the 40th year anniversary, and we have a jammed agenda. We're going to try to do that, but it will be renewed. It doesn't expire until 07. I'm very much with you on the objectives and what we have to do. The memoranda which are referred to, and there are quite a number of them, go back to Judge Roberts' days as a young lawyer, and he has testified that he was representing a client, and we had real battles with the Reagan administration. There's no doubt about that. And I was involved in them, notwithstanding the fact that it was my party. But Congressman Lewis, I would like your views as to how you regarded what Judge Roberts said in explaining his views at the time, or what the memoranda said, which he said were not necessarily his views, and you have to evaluate that, contrasted with very close questioning by Senator Kennedy and others where he did not raise objections or said he did not have an agenda to turn back the clock.
Well, it's my view, Senator, that, Chairman, that the judge was on the wrong side of history. He was on the wrong side of the voting rights side, not just the letter, but also the spirit of the act. It is very hard and very difficult, almost impossible to prove intent. You don't have, I think Vernon Jordan, the former head of the Urban League, said on one occasion that you won't have people in the American South, in the 11 southern states of the old Confederacy, from Virginia to Texas, putting up signs saying we're going to discriminate. We're going to keep black people from getting elected. They're not going to do that. I was young too a few years ago, 24, 25, but I tried to do the right thing. I got in the way. And I think Judge Roberts, as a young attorney in the administration of President Reagan and others, failed to go with his gut. Maybe. Did he go with his gut? Did he go with his heart? Or was this his views? You don't come back years later and say, oh no, this was not my view. Sometimes you have to fight. Sometimes you have to get in the way. If you can't get in the way when you're 25 or 30, you're not going to get in the way when you're 50.
Thank you, Congressman Lewis. I just have a minute 40 left, and I want to give Governor Thornburg an opportunity to comment. Based on your knowledge of Judge Roberts, and you worked with him at a time when he was young, do you think that those memoranda reflected his own views as to civil rights, or what do your insights and your knowledge of Judge Roberts tell you as to what we might expect of him as Chief Justice, if confirmed, on these issues?
Let me say just three things in response to that, Senator. I have never seen any evidence of any hostility to civil rights on the part of Judge Roberts during my professional and personal association with him, which goes back some 15 years. Secondly, I think it is important, and Justice Ginsburg was quite definite in this and her appearance at the time of her nomination to separate out the views that are expressed as an advocate for a client and the views that might obtain if the individual were speaking for him or herself. And thirdly, I don't think any of us could stand, perhaps my friend John Lewis could because of his distinguished career, but I don't think any of us could stand a complete and thorough rummaging through the views we expressed when we were 20 or 25 years old. I shudder to think that some of the things that I had in my craw at the time would stand the test today. But most importantly, I think is my conclusion that on the basis of my personal knowledge of Judge Roberts that there's no hostility there to civil rights. There's a veneration of the rule of law, and to the extent that the rule of law permits, it seems to me that he would be a strong supporter of equal rights and equal treatment and equal justice for all under the law.
Thank you, Governor Thornburg. This is a very, very distinguished panel. We could hear a great deal more, but my time is up, and I have to set the lead on observing the time. Senator Leahy, do you care to question?
Just more a comment, and of course, Governor Thornburg is a friend of all of ours. We worked with him during his time as the Attorney General, and when you mentioned Justice Ginsburg, just so the record is clear, her appearance here is a lot different. She answered questions from numerous senators on race discrimination and affirmative action. Several other senators, she answered questions on gender discrimination. Several other senators, she answered questions of reproductive rights. From several other senators, she answered questions on death penalty. And then First Amendment, freedom of speech, religion clause of the First Amendment, separation of powers, unenumerated rights, 14th Amendment, role of the court, deference to Congress, and then had 3 or 4 that she didn't answer. But she answered specifically, both Republicans and Democrats, very intensive. I only mention it because there seems to be some view that when Judge Roberts took, I think, too much to heart the recommendation made by some of the senators here not to answer questions, he took it too much to heart and did not answer those questions. When my friend John Lewis talks about times to get in the way, he knows of which he speaks. He nearly died doing that. But he's doing it for the right cause, the cause of civil rights. And I think every African American and every white American and every brown American, everybody else, all Americans, have to thank you for what you did. I'll yield back my time.
Thank you, Senator Leahy. Anybody on the other side of the aisle want to say
Could
anything?
I have one thought, Chairman, just real quickly, if I could? And I want to welcome the panel, and particularly my friend John Lewis. We worked a lot on the African American Museum of History and Culture that's going to be here in Washington, D.C. Sometime soon. We got that passed through. Judge Jones, if I could just ask you a real brief question on this, because I hear your concerns and I hear the thoughts, and I respect the thought that you're putting forward here. Judge Roberts asked, when people asked him, I think Senator Durbin asked him, how do we know what kind of judge you're going to be on some of these issues? Obviously, you got a great head, but I want to look at your heart, and it's hard to see a man's heart. And Judge Roberts' response said, well, look at how I've ruled the cases thus far, which there are not a lot of. I think 52 cases thus far, but it does have one, Washington Metropolitan Transit Authority, where he ruled against the D.C. government's claim of sovereign immunity and in favor of a workers' disability discrimination lawsuit. That's kind of thin, but we only have 52 cases, and that one's there. And then he also talked about his dedication to rule of law, and that's really what drew him into the law. And if he is sufficiently dedicated to that rule of law, given the laws now that we have on books, to work to protect civil rights and a number of other issues, shouldn't that give some solace that if his heart is right on defending the rule of law, given if we've gotten some of the laws better and right now, that he could be quite a good judge for civil rights cases?
Thank you for your question. And I would respond this way. I'll respond both as a former litigator, civil rights litigator, and as a judge. As a judge, we look at the record. The record that has been made here, the part of it that I have observed, shows an early disposition to take positions contrary to civil rights enforcement. The burden that is now imposed upon him and imposed upon this committee is to be satisfied that the presumption, or at least the inference, that one can draw from that prior record has been overcome, and that he doesn't share those views at this time. That's a burden and judgment this committee has to make. I would also point out that, if I may just be a little personal, at the time I left my job as a general counsel of NAACP, a position that I had occupied, which Thurgood Marshall also occupied, I had been involved in litigating major civil rights cases all across the country. I joined the court upon appointment by President Carter in 1979. At that time, we thought generally that certain civil rights principles were settled. We thought that the issue of school desegregation was settled in light of Chief Justice Berger's decision in Swan, in which he said that busing and transportation was an appropriate remedy when you had a finding of constitutional violations that rigged a school district. We thought the issue of affirmative action was settled with the Bakke case, with Justice Powell's plurality opinion, which he says you may take race into account. But we find that following that case, those cases which I thought were settled, I was then sitting as a judge on the Sixth Circuit Court of Appeals, and I was engaged in dealing with the first wave of attacks against school desegregation and against affirmative action. The challenges claiming preferential treatment, claiming forced busing, all of these buzzwords were coming at the court, and we were then faced with the decision, are these principles settled? And I've now learned that in the boiler room of the Reagan administration, stoking out and crafting a lot of the theories that were being used in the courts to attack these settled principles was the nominee. Now that raises a question for me and for you of this committee to decide whether, if one is a believer in the rule of law, why one would not accept Swan as settled law, would not accept Bakke as settled law, would not accept Weber as settled law, the whole body of jurisprudence that had been built up to reaffirm the value of remedial actions when it was clear that we had this vast history of racial discrimination in this country.
If I could, before my time runs out, just quickly say I appreciate the thought.
Would you make it quickly, Senator Brownback? We have to move on.
Okay. That I would note what Judge Roberts has ruled, what he has done as a judge, and I would hope people could look at that in the fair light of what it is and indicating his judicial temperament and nature. Thanks, Mr. Chairman.
Thank you very much, Senator Brownback. We're going to break for lunch at the conclusion of this panel. Senator Kennedy?
Thank you very much, Mr. I don't think any of us in the course of the time questioning Judge Roberts ever suggested that in any way he had any hostility on the issues of race. I really think the question was, does he get it? Does he get it? Just what the good judge has pointed out, the march towards progress that we have seen over the recent years. So I'd ask Mr. Henderson and then John Lewis, how about this argument? Well, he was just an attorney. He was just an attorney. He was speaking for an administration. He was just taking administration's position. So we shouldn't be too harsh on this. Sure, the administration just wanted the reauthorization of the intent test. He was just following orders, so to speak, on this. And so why should we not assume that he gets it with regards to the issues of this nation's great challenge, the poison of discrimination that's there since the first days of it, and we've all seen, including in my own state of Massachusetts, the challenges that we have faced. Why can't? What's your response to that?
Well, Senator, I certainly recognize a legitimate argument that an individual representing a client often projects the views that best suit the client. But I remind you, sir, that Judge Roberts never once distanced himself from positions articulated in many of the memoranda at issue in a way that would give comfort to the notion that he, in fact, had not internalized these views to reflect his own policies. Judge Roberts has a vision of judicial restraint, and he's articulated it himself, which is really a retreat from the role of the federal courts in protecting civil rights. And I guess, you know, from my view, this is really not an academic debate. It's very personal. I mean, I grew up right here in the nation's capital. I was 16 before formal segregation ended by law. I know what it's like to be on the politically disfavored side of the color line. And I know that the federal courts have played an important role in helping to ensure equal opportunity for all of American citizens, and we're not prepared to take that risk. I would simply say that even in today's society, Senator Brownback mentioned earlier, well, laws have changed, things have happened, they've improved. Certainly that is true. But in the words of William Faulkner, you know, the past is never dead. In fact, it's not even past. And just to confirm that point, I have a pending complaint right now before the Department of Justice for a case of public accommodation discrimination from a hotel in New Orleans over the 4th of July weekend in an area where I thought change had been made in a lasting way that would not have permitted that to happen. I know firsthand what that stigma is about, and I just reject that analysis.
Well, Senator? It is true that we did ask him. I asked him about whether any of these positions that he had taken at that time, whether he would reverse any of these, and we didn't hear a response from him that he might. Let me ask John Lewis to comment on that, and then also in the comment. I've got a minute and a half, John, so you know this business. So I hope you'll respond to the earlier question for Wayne, but I hope also when Judge Roberts was asked about the intent test and the effects test, and he was asked also by members of the panel, well, if we had actually had the intent test, do you think we would have made the progress that we would have made with the effects test? And he said, I'm not so sure we might not have made the kind of progress on that. We know the earth-shattering progress that has been made with the election of officials locally, state, and at the federal level, and the progress that has been made with the effects test. I'm interested in someone who knows and believes that the Voting Rights Act is the key civil rights issue. What's your own view on this question? How could anyone view that if we had had the intent test, we'd be where we are today? Wouldn't we be a different land?
Well, I tell you, Senator, as someone who worked in the American South for several years, directed an organization called the Voter Education Project for 7 years, trying to get people registered, trying to get people to lose that sense of fear. People, I tell you, we wouldn't be where we are today. The American South would be different. The country would be different if we had relied on the intent test. I wouldn't be here as a member of Congress. And a lot of my colleagues in the House of Representatives, and a lot of the elected officials all across the South, before the Voting Rights Act in 1965, there were less than 50 black elected officials in 11 southern states, from Virginia to Texas. Today, there are more than 9,000. We wouldn't have made it. There still will be people trying to get elected, and they wouldn't be elected. I don't buy this argument that he was just doing his job. He was just following the rule. By this time, you had the 64 Civil Rights Act, the 65 Voting Rights Act, the Fair Housing Act of 1968. By this time, there's someone in the administration, they should have a mindset. I think this says something about Judge Roberts' mindset. He didn't stand up and argue against this attitude. He didn't speak out. He didn't send a memo saying something different.
My time is up. Thank you.
Thank you very much, Senator Kennedy. Senator Durbin.
Thank you, Mr. Chairman. Thank you to the panel. Let me first thank my colleague, Senator Kennedy. I think that during the course of this inquiry of Judge Roberts, he has been laser focused on civil rights and the Voting Rights Act, and I think it's done a great service to the operation of the committee, and I hope that we all appreciate how much work went into it. But I do recall, Senator Kennedy, on the first day when you went into this, I made notes how Judge Roberts said repeatedly, that was 23 years ago. I was a staff lawyer at the Justice Department. That was the position for the administration I worked for. It was my job to articulate administration policy. We heard that consistently whenever we brought up these memos. And so I thought to myself, well, in fairness, if we're going to allow him to use that explanation, what does he feel today? What can he tell us today? I personally believe in redemption, in faith and politics. And I think, John Lewis, you have seen so many in the past who were on the wrong side of history on civil rights who realized it and conceded that and moved to a different position. During the course of this hearing, we asked Judge Roberts many questions. In fairness to him, one of the few direct questions he answered was when I asked him about Bob Jones University case. And he said, I disagreed with the position of the Reagan administration. I'm glad he said that. I wish he could have told us more. Then I tried in my last round of questioning to get down to a point of where would you draw the line as an advocate? Are there some things you would not bring your legal skills to? You have spoken with pride of Romer versus Evans and the fact that you counseled gays and lesbians who were about to lose their rights in Colorado. And just a few hours ago, I asked him sitting at the same table, could you have taken the other position to restrict the rights? And he said yes. And so it comes down to a fundamental question. I don't think I understand if there is a clear, bright line in his mind when it comes to this issue of freedom and when it comes to this issue of liberty. And that troubles me because I think knowing that, I'd feel more confident that he could lead this court. But I'd like to ask you, John Lewis, on the issue of redemption. Do you feel that even if he was totally wrong 23 years ago or 24 years ago in his memos, that people can change?
Well, I think it's possible and it's conceivable, Senator, that people can change. But when you believe and feel and know from your experience, or maybe from the law and from history that you've been wrong, you show some sign. And you're not afraid to talk about it. You're not afraid to go on the record. Judge Roberts has been afraid to show or demonstrate in his signs that he's changed. I wonder whether it's part of his mindset.
Well, I think that's the point, and maybe Wade Henderson made the same point, that when Senator Kennedy went directly to the Voting Rights Act, much like Bob Jones University, he could have made it clear that that position was just wrong and that history had proven it wrong. And yet, for 2 successive days, it came up short. Wade Henderson, you've made that point in what you had to say here. The critical questions, values, and just not competence here and what we're dealing with. And Judge Jones said the same. And so I don't want to dwell on this any longer other than tell you, for me, this is the threshold issue. The issue of race is the threshold issue. I have to be convinced in my mind that Judge Roberts comes to this critical job as the head of the 3rd branch of our government with a clear understanding of what we must do in this country still to deal with the issues of race and justice for so many minorities in this country. Thank you all on this panel. Thank you, Mr. Chairman.
Thank you very much, Senator Durbin. Thank you very much.
Mr. Chairman, with your permission, if I could just make one quick clarification.
Go ahead.
We've been talking, thank you very much. We've been talking about redemption, and I don't think that John Roberts needs to be redeemed in any sense whatsoever, but to the extent one claims that his position on the Voting Rights Act was somehow wrong prior to the effects test, let's take a look at the facts. After the effects test was implemented, what did Judge Roberts do? He argued Chisholm versus Romer. He argued the Houston Lawyers Association. He argued for an extension of the effects test to state judicial elections. If he redeemed himself at all, he clearly did it right there. So we have facts here. This is not speculative. In terms of looking at his heart, if it's conflated with what he's done on the court, and I don't know that you can necessarily discern that, we have absolute evidence of what he felt about enforcement of the effects test.
Thank you, Commissioner. Senator Sessions wants a minute recognition before we break for a very abbreviated lunch.
Thank you, Mr. Chairman. I would just like to add, I've been listening to some of this as I could. I would just like to add that we've heard explanations from Judge Roberts on each one of the memorandums he wrote, each one of the situations that he was called to express an opinion on, such as the effects test. His ruling was absolutely consistent with the Supreme Court ruling of the United States at that time. So all I would say is I think it's unfair to suggest that he has a record that indicates that he was somehow wrong on civil rights at that time. Yes, he opposed quotas. Yes, he supported the extension of the Voting Rights Act completely, but he did not favor its alteration to overrule the Supreme Court opinion. So I would just, for the record, like to say I believe his record does show affirmatively that he is committed to equal justice under law, which is what he's called upon to do.
Thank you very much, Senator Sessions. Senator Kennedy, you have a unanimous consent request.
Consent that the NAACP Legal Defense Educational Fund prepared some important testimony that will be made a part of the record.
Without objection, it will be made a part of the record. Thank you all very much. We have so many witnesses, we're going to have an abbreviated, not a lunch hour, but a lunch half hour. We'll resume at 2 o'clock.